Welcome back to another episode of the Partners of Commercial Fishermen podcast. I'm your host, Megan Waldrop, and I am thrilled to have the partners, the fishermen, friends and family, supporters of anybody that stumbled upon this podcast. We are stoked to have you. And if you're new here, I'm Megan Waldrop. I'm your host, and we are thrilled to hang out every week and talk about the intricacies of the commercial fishing lifestyle, a lifestyle that not a lot of people can relate to. The closest people that could possibly understand are military spouses and families. And even then, within the military, there's nuances. Within commercial fishing, there's even, of course, as we know, so many freaking nuances, as many as there are species of fish in the sea, possibly even more. So on that note, as partners, we know the risks of commercial fishing. We probably think about it more often than not. And what I've realized is, how can we find more peace? Some of that peace of mind can come from knowing that if an injury happens, we have the right legal guidance, which is crucial to help us on the next steps. Like, how do we protect ourselves and our fishermen? And what do we do next? How do you even know what to do next? Not something that ChatGPT or Google can help you with. You need an actual legal guide. And this is why our next guest, whom you know if you listened to last week's episode, has helped countless fishing families navigate legal challenges and secure the compensation they deserve. In this episode, we welcome back Attorney Michael Flynn. And today he explains the meaning of the Jones Act, a maritime law that provides compensation for injuries sustained at work. And he breaks down the Seaman's Protection Act and how it supports fishermen. We discuss proactive education for fishermen and POCFs, what we need to know before and after an injury happens, as well as considerations for fishing families in legal matters. Michael explains the legal fee structure, how lawyers and fishing families get paid, and how the case is managed, and how often you can expect to hear from Flynn if you choose to use him as an attorney. And by the way, you can live anywhere in the U.S. and have access to his services. We also discuss the ongoing safety initiatives and the Seaworthy Foundation's efforts to improve vessel stability regulations and safety equipment for commercial fishermen. And as a cherry on top, Michael answers the questions you submitted through our private chat community and in Instagram comments and DMs. So thank you all so much for sending those out. And shout out time. I'm proud to say that Attorney Michael Flynn is now a sponsor of the POCF community. And through this episode and the one last week, if you haven't heard it, go back and listen to it. You will see why I am super protective, as I say, of our community, which means I only partner with people and products that are high quality and truly best serve our commercial fishing families. For that reason, consider Michael Flynn your go-to contact for any questions about commercial fishing personal injuries that may arise. He also offers free consultations, so you can decide on the next best move for you. He's super chill, as you'll see in this episode and the one last week. Very easy to chat with. He totally gets it, has compassion, empathy, and he stands up for the rights of commercial fishing families. It's really, really amazing. And I'm going to mention more of it in the episode and in the show notes, but I'm going to share it with you here too. You can contact Attorney Michael Flynn directly via phone or text. He loves a text. For that free consultation, you can reach out to him and schedule that today. And you can reach him at 617-773-5500. You can also get him through email at mflynn@flynnworkus.com or on their website at flynnworkus.com. That's FLYNNWIRKUS.com. Let's dive in. I'm Megan Waldrop, host of the Partners of Commercial Fishermen podcast, an extension of an online community for partners to connect and feel less alone. Our podcast invites fishermen, family, friends, and supporters of the industry to learn, laugh, vent, and hear stories about this incredibly unique way of life. What do you say? Let's dive in. So you've already kind of hit on this, but wondering if there's kind of an ABC of what are the basic rights of commercial fishermen?
The basic
rights. Yeah. What are the,
okay.
Yeah, some of the basic rights of a commercial fisherman.
So we touched on before, if you're, and this is important, this is more than injuries. So I mentioned the COVID case. Okay. So the theory there is that the client, the fisher, contracted an illness, came down with a condition while in the service of the vessel. And those things, in an injury, if a dredge falls on you or you're thrown overboard and you get injured, sure, that's an injury. It happens within the service of the vessel. That triggers the obligation for the vessel owner or its insurer to pay maintenance and cure, which we talked about at the outset, which is the living expenses and the curative medical treatment, the bills for that. So that's the first right of recovery. That's the first kind of bucket of recovery that you can have. Understand this about the maintenance and cure concept. So let's say a person has a bad back and they are fine. They've had it before, but they're kind of okay. They're good to go on the trip. But then they go on the trip and that manifests itself again. So long as it's in the service of the vessel, there's an obligation to pay maintenance and cure. Okay. Let's say a person has, I don't know, I'll go crazy on this. Let's say they have cancer. Okay. And they don't know they have cancer. They get on the boat and all of a sudden they feel sick and they come down with the symptoms that are associated with the cancer while they're in the service of the vessel. The vessel has to pay maintenance and cure for that. They don't have to pay the Jones Act damages for that, which we'll get into, but they do have to pay for the maintenance and cure. Okay. One the thing about what does it mean to be in the service of the vessel? So that can be a wide range of things. And I'll give you an example. Obviously, if you're out fishing, you're in the service of the vessel. If you're doing gear work or lumping at the end of the trip, you're in the service of the vessel. That's kind of obvious, right? But what if the greenhorn gets sent out to, so let's say he's going out to get coffee for the crew and he gets in a car accident. He's in the service of the vessel. So that would be covered by maintenance and cure. Okay. So that's your first thing. It's not going to pay you a lot. Doesn't pay you comp. You're not going to get your wages. But it is going to pay you something. If your living expenses are more than $34 a day, if you have the right representation, your lawyer will be putting together with you the necessary documentation, bills and such, to demonstrate that you're entitled to more than the average amount. I have a client who was putting 4 kids through college, had 2 properties, and all sorts of bills, and we were able to get the insurer to pay a lot more on the maintenance side because the living expenses were just so much more for that particular client. So that's the first bucket of recovery. The other one is Jones Act, which I mentioned earlier. So the difference in the Jones Act is that you have to prove that the vessel owner failed to provide that reasonably safe workplace that the statute that Congress adopted in 1920 mandates. And you have to prove that there was a negligent failure to do that, but you also have to prove that the injury that was suffered was a causative result of that negligent failure to provide the reasonably safe workplace. What's important about that aspect is that in the statute itself, the Congress says, so long as the vessel owner's failure played any role, however slight, actually the Supreme Court, that's the Supreme Court's language interpreting the statute. So let me go back again. The statute says, so long as a vessel owner's negligent failure was a cause in whole or in part of the injury suffered, then the vessel owner is liable for the full amount of the damages. The Supreme Court subsequently interpreted that to mean in whole or in slight causation. Now, that might not seem a lot to our listeners today, but most negligence cases, the causation
standard is proximate cause, or words to that effect, depending on what state we're talking about, which again, depending on the state, means something along the lines of a substantial contributing cause, or something called but-for causation, meaning that the injury would not have occurred but for the negligent conduct of the defendant.
That's the standard, which is a lot more difficult than in whole or in part, however slight. What it means is that so long as the negligent failure to provide the reasonably safe workplace played any role in contributing to cause the injury, the vessel owner is on the hook for the full amount. So if there's 1,000 causes for an injury to a fisher, and just one of them is the negligent failure to provide the safe workplace, you're going to get your recovery. And that was specifically intended by Congress when they adopted the act back in 1920. So what do you get out of the Jones so far? But you get your pain and suffering, past, present, and future, mental, emotional, and physical. Okay, and that's something that a worker that's injured outside of fishing, like a construction site worker or something like that, they're going to get comp. So they're going to get part of their wages paid, but they're not going to be entitled to pain and suffering, at least not against the employer. And that's who you're suing under the Jones Act, is your employer, whoever that might be. And you get the pain and suffering. And then you get the jury gets to consider other aspects of your damages to determine how much to give you. So it's not a quid pro quo, but they get to consider your lost earnings, past, present, and into the future, as well as the amount of your medical bill. Okay. And so we always talk about what a jury is going to entitled to hear and how they're entitled to determine how much to award in damages. But 95% of cases settle. So when we settle, we're trying to figure out, okay, what do we think a jury might do with this based on how they will be instructed? So that's what the Jones Act provides. Do I make that clear, kind of how the damages work under the Jones Act? So you got maintenance and cure, you're going to pay your medical bills, going to pay your living expenses, so long as you're in service of the vessel, a lot broader an area. Jones Act, you got to prove the negligent failure to provide the workplace, so long as it played any role whatsoever in contributing to cause the injury, you get your damages, includes pain and suffering, lost earning capacity, medical bills. So that can be a lot. Okay. What it doesn't cover is consortium. There's no right of consortium under the Jones Act. That can be significant, and particularly to the listeners of this podcast, okay, where we're talking about the significant others. So if you're in a car, or if I'm in a car and I get hurt and I sue in negligence against the driver of the other vessel or the other car, I'm going to get my damages, which are similar to the Jones Act damages: pain and suffering, wages, bills. Jury's going to give me what they think the loss was, how badly I've been injured. But my wife also has something called a loss of consortium claim, which means, if I'm seriously injured, well, I'm not the only one impacted. My wife's going to be impacted by that. She's going to suffer. We might have intimacy issues. She's going to be worried. Depending on how serious the injury is, she might, have to take care of me, okay, and put her life on hold. Well, most theories of liability provide her a recovery for that. And so a loss of consortium claim can be significant. For whatever reason, the Jones Act does not allow loss of consortium. A little editorialization, it's kind of speaks volumes to, on the one hand, when Congress set out to provide a remedy for injured fishers, they really wanted to have a very pro-fisher remedial recovery, and they wanted it to be liberally construed. But then at the same time, they kind of showed us how they valued fishers, the limited value they placed on fishers. Why wouldn't a fisher's wife be entitled to loss of consortium? Where that same fisher falls on the dock due to somebody's negligence. It's going to be harder for them to prove their case against, let's say, the dock owner, but the wife's entitled to loss of consortium. But if the fisher's 2 feet off the dock in a boat and the same thing happens to him or her, the wife doesn't get recovery. So it's kind of crazy to me. But there's more on the Jones Act, but that's kind of it in a nutshell. The other avenue of potential recovery is the unseaworthiness claim, or the main recovery. There's some other ways to get recovery, but that's the main one, unseaworthiness, which I mentioned earlier, which requires the vessel owner and the vessel itself to be staunch, fit, and in shape for its intended purpose. There's a hole in the hull and the vessel goes out to sea and sinks. Well, it was pretty obvious that was an unseaworthy condition. But there's other less obvious conditions which can be considered unseaworthy. For instance, insufficient manpower, insufficient for the task at hand, insufficient training, okay? The violent tendencies of a crew member who physically assaults another crew member. All of these things, amongst others, can make a vessel unseaworthy. An unfit captain, okay? Let's say the captain doesn't know what he's doing. Let's say the captain falls asleep. Let's say the captain's drunk. That all of those things make the vessel unseaworthy. The decision to fish in bad weather can even make the vessel unseaworthy, because if you can demonstrate that was due to the lack of judgment on behalf of the captain. So there's a lot there. As I mentioned earlier, a strict liability standard, which means that you don't have to prove negligence. All you have to prove is the condition and that it proximately caused. So the causation standard is a little bit different. We're getting kind of into the legal weeds here, but it's a different causation standard on seaworthy. So it's just the condition, even if they were not negligent, but the condition is there and it approximately caused the injuries, then there's recovery under that theory as well.
Thank you for explaining that. I just want to make sure that I understand the word consortium. Can you explain what that means in the terms that you were just speaking about?
So loss of consortium is loss of comfort, care, advice, society, and the benefits of the relationship. Okay, that's kind of the legal terminology that's used to describe it. What it means is that if you are in a relationship with somebody, you have an emotional attachment to that person. You have sex with them, so there's intimacy. That's how the relationship is manifested. If it's your husband or your wife, you get advice from them. You talk to them. They comfort you. They're your society. They're your friend and your partner. And if that relationship is affected to the detriment of the relationship, then that is considered loss of consortium. Technically, it's a theory of liability, okay? But it depends on in some part, the underlying case. And by that, I mean, one partner is injured due to the negligence of another. The other partner, who's not involved in the injury, but suffers a loss, i.e. their loss of consortium, then they also have a right to recovery because they were also injured, arguably because of the conduct of the negligent party. But that is not available under the Jones Act or in a maritime context for an injured fisher. So
great. Thank you for explaining that. For sure. I actually question about, because we are partners of commercial fishermen, which means it's not just married. We're not just fishermen's wives. We're girlfriends, we're fiancés, we're long-term committed partners. So that means that even if you're in a long-term committed relationship without a legal marriage, I forget what it's called, like a certificate, whatever we signed whenever we got married.
Yeah, a document.
The document,
license,
the signed.
License.
We reported it. We reported it. It's legal. So even if you don't have that kind of legal document, are you still protected?
No, so you're not. In most states, I believe, and I'd have to check and research this, but I believe that there may be some states that recognize the a right of consortium for the significant other who is not a spouse. Okay, but it's also my belief that most, if not all, states, you've got to have that legal relationship, and then it's recognized. There are other relationships, for instance, the dependent minor children of an adult parent. Okay. So in that same car accident I was talking about earlier, my wife, if I'm injured badly enough, my wife would be entitled to loss of consortium. If I had minor children who were dependent on me, then they too would have that right. Once they reach the age of 18, they don't anymore. So there's that. And they're depending on the state, and the listeners may have picked up on something and perceived it. They may have also be confused by it. Federal versus state. Okay, we've talked about both today. Okay, a fisher's rights when injured on a vessel or when suffering an illness condition or an injury that manifests while on a vessel are entitled to maintenance, cure damages, unseaworthiness damages, and Jones Act damages All of that stems from the Jones Act is a federal statute, and the other concepts are federal common law, okay, judge-made law. In a garden variety negligence case, that is going to be governed by the state, okay? So every state may have different and do have different quirks on what you have to prove in order to recover in a negligence case and what damages you would be entitled to or your significant others would or not be entitled to. So we'd have to look to the state to determine the parameters of garden variety, non-maritime negligence recovery. And the other thing about federal versus state is in the Constitution itself, the federal government or the federal judicial system, the federal courts are granted jurisdiction over admiralty claims and maritime claims. So you have the option to, an injured fisher would have the option to sue in federal court as a court of original jurisdiction for Jones Act unseaworthiness and maintenance and cure. They also have the right under a separate statute called the Savings to Suitors Clause to not file in federal court and choose to file in state court if they so desire. So I'm touching upon some very complex legal issues. Thought people might be interested in to hear that and to understand the differences between federal and state and how they can kind of proceed on parallel tracks.
And so this is great. Question about when you say state, are you talking about the state that the vessel's registered in? Are you talking about the state where the accident may have happened? Are you talking about where, the state of, what does that mean?
So you have just articulated a law school, not a law school, a bar exam question, okay? And one of the first things we learn in law school is jurisdiction, venue and jurisdiction, okay? And what that means is where am I required to file certain lawsuits and where do I have the choice to file certain lawsuits, okay? So in order to file any action, you have to file it in a court that has jurisdiction over it, okay? I like to talk, I've talked a lot. I really enjoy all these topics, so I could go on forever about any of them. But I got to cut jurisdiction short because it can be wicked confusing. There's a lot to it. It takes about a semester, like the first semester in law school in your civil procedure class. This is what you're learning. So it's really, in my Northeastern New England vernacular, it's wicked hard. Okay, let me see if I can simplify it. So you have to file in a court that has jurisdiction over the claim. So it's easy when it comes to a quote unquote admiralty or maritime case, and I'm using that term broadly. But Congress in the Jones Act said you can file your Jones Act claim in federal court. They have original jurisdiction. The Constitution says that the federal court have jurisdiction over admiralty claims. Okay, so there's jurisdiction. Congress says so. The Constitution says so. Okay. When it comes to a garden variety negligence case that's not governed by a federal statute, then we're talking about the finding the right state that has jurisdiction over it. Okay. Let me just circle back one other thing. I mentioned the Savings to Suitors Clause. That says that with respect to the maritime and admiralty cases, the fisher has the right, if they want, to choose their forum. In other words, to sue in state court, even though they have original jurisdiction in federal court. They have the option to sue in state court if they want to. Okay? So jurisdiction is easy when it comes to those cases. Now, when it comes to a garden variety negligence case, you're talking about different factors which depend on the residency and or of the party and or the location of where the accident took place. And that also gets us into another area of law called choice of law, which means that you might have jurisdiction to file your case in Massachusetts, but because of various circumstances, New Hampshire law might govern it, okay? For instance, the accident happens in New Hampshire, but the plaintiff and the defendant are both residents of Massachusetts. You can file in Massachusetts, and then, but New Hampshire law is going to govern.
I have a two-part question for you.
Okay.
And I feel that you've been doing this so well this entire time. So thank you so much. So what kind of proactive education do you offer to help fishermen and fishing families before legal issues arise? Second part, and what should fishing families take into consideration before making decisions that may impact their case?
Okay. So proactive education. So unfortunately, there's really not a lot of opportunity where that's presented. Okay. And we try as much as we can to be in the community and to be there, and provide answers to people about questions they might have. But that almost kind of comes up on a case by case basis. That said, I'm sure at some point we'll talk about Seaworthy, the nonprofit that I'm involved with. And so through Seaworthy, there's much more of an effort to actually reach the community and provide various, educational types of forums through that. And we're always working on that to do that. I do have mentioned Jim Comfort, who's my client service coordinator. So Jim is in the community. We do have an office in New Bedford, which is very important that we have our satellite office there. And Jim is there most days a week. When he's not there, there usually is somebody from the office there. So it's important to have that presence so people can come in and get answers to any questions that they do have. So what was the second part of the question? What's the advice to them, decisions that they might make that might affect their claim? So we've talked about them a lot, right? We've talked about the report it, record it, represent it, and get the medical treatment correct. Correct two ways: get it correct in the way that they record accurately what happened to you, but also that you are being treated by the right specialist. So those are the most important things. Preserving the evidence, taking photographs, whatever you can to preserve the evidence, preserve that you reported it. Those things, and don't talk to the insurance investigator until you've talked to us. Those things are the most important things you can do at the very outset that are going to affect your claim. Here's the next thing to do. Okay, get off of social media. Social media can invariably harm you after a claim, because no matter how injured you are, okay, if you put anything out on Facebook or on Instagram that makes it look like you're happy or you're actually living a life, the defense is going to bring that out, potentially going to bring that out in a litigation and say, oh, you claim you're so injured. Well, on such and such date, you were at a birthday party, weren't you? And so that kind of stuff can really, really, really be harmful. The other thing is, in all aspects of this, tell the truth. Okay? Tell the truth. You can't, if you're even perceived as not telling the truth, that's going to be fatal to or damaging to your ability to get a good outcome in your case. And we especially want you to tell the truth to us as your lawyer. And we especially want to know the stuff that you might think is bad, okay? Because unless we know stuff, we can't deal with it. But if we know it, even if it's something you might think is bad, we can get ahead of it and deal with it in the best way possible. I have a question which is raised by my clients a lot, because when I explain how a case is valued, I usually use a poker analogy. Which some people may understand, some people not. But I feel like most people understand poker, right? So in poker, let's say it's Texas Hold'em. There's a pot, and you're holding cards, and everybody knows what a good hand is. 4 of a kind's a great hand. 5 cards off suit, you're not going to win anything. So in any case, we look at liability, which means what are the chances I'm going to prove the case and win if we ever go to a jury. The other part of the case is the damages. If we win, how much do we stand to recover? What's the value of the case? And you kind of take those two things together to answer that question. So if on liability, you say, I got a 50-50 shot of winning this case, which that's not science, nor an art. It's just try to predict it. And the damages are somewhere between two numbers. You take 50% of that, and that's what you can kind of tell the client is a reasonable value. That's one way of analyzing. But when we look at it in terms of poker, liability is what are the cards you're holding, okay? And if you got a couple of aces in the hole, so to speak, okay, I got a pretty good liability case. I'm going to play that hand. I'm not going to fold. Now you look at the damages. And in a Texas Hold'em style match, you're looking at how many people have put their chips on the table. Those are damages. How much can I recover? So you can have a real good liability case with not a lot of damages, and so it's not worth that much. But you might have a crappy liability case. But I hate to be macabre about it, but let's say there's an amputated leg or a brain injury. Well, those are significant damages. So if I do win, I'm going to get a lot of money for my client. So we look at those things. And when I describe the damages I mentioned earlier, what is the jury going to be instructed that they can consider to determine how much to make the injured person whole? In other words, to put them in the same position they would have been in had they not been injured due to the negligence of the defendant. That's pretty much what the instruction is and emanates from. And then the judge will then instruct the jury, these are the things you can consider in determining what this person has lost. And I mentioned them earlier. Lost earning capacity, just subjectively, objectively, how much have they lost? Emotional pain, physical pain, mental pain. But lost earning capacity is important, and medical bills for the jury's determination, not quid pro quo. On the lost earning capacity, the more you've lost in terms of earning capacity, the more chips are on the table, symbolically, i.e., the bigger your damages potentially. So that invariably leads clients to ask this question. Well, so the longer I stay out of work, the more my damages are and the bigger my case is, the more it's worth. And my answer to that is no. My answer to that is if you don't go to work when your doctors say you can and you feel like you can, then you're essentially lying. And you're kind of trying to extend something for the purpose of the case. And I always tell my clients, don't ever do anything for the case. You live your life as if you don't have the case, okay, when it comes to these types of issues. And if you can go back to work and you feel like you're up to it and your doctors are telling it to you, go. Don't stay out just to make that lost earning capacity number bigger. And I found that juries tend to reward, and insurance companies tend to value clients who bust their fanny to try to go back to work, rather than those who don't. And what the defense says is gild the lily, try to make more of a case that is less. So I'm trying to answer the question of what advice to give, and the overall one is, and the other things we talked about, but stay off social media because you don't want it to be misconstrued and used against you. But don't talk to us. Tell us the things that you think are bad. So some clients will say, well, I'm going back. I think I can go back to work. Okay, great. Thanks for telling us. Now we know that and we'll deal with it. And, I have a case right now. The guy is hurt real bad, doesn't have the use of his arm. He has spasticity, which means he loses control of his legs. Sometimes he has spinal cord injury and some other things. Yet he's trying to go back to work. And I think that a jury is going to tend to look at this guy and probably want to give him more money than somebody who would not try to. So I kind of went off a little bit on that topic, more to give an example that, live your life. Do what you would be doing but for the accident, and just be honest with your lawyers about it and let them deal with how those chips might play out.
There's one subject that we're constantly talking about, whether on the podcast or in our Partners of Commercial Fishermen community, and that is safety. And here's a hard truth. Did you know 8 out of 10 fishermen lost at sea weren't wearing a PFD? It's time to change that. At Kent Safety Products, they make life-saving gear designed for real fishermen. No bulk, no hassle. Just protection that works when you need it most. They also have the most Coast Guard approved PFDs on the market. So whether you're fishing in hot or cold environments, a fisherman can find one to fit their needs. And partners, Let's just pause for a moment and think about how much it would ease stress to know that your fisherman is protected each time they go to sea. It's a lovely thought, right? And as a side note, we only partner with companies that have heart, those who truly want the best for our fishing communities and have high quality products. That's why I am proud to have Kent Safety Products as a sponsor. Visit kentsafetyproducts.com and find the right PFD for you and your fishermen. That's kentsafetyproducts.com. And for those who want to hire you as representation, what is your fee structure? And if we could talk about how are settlements distributed? Like, what's the percentage that a fisherman might get if they have like a $2 million lawsuit?
So this is another aspect of the relationship that we try to explain to our clients right off the bat, even before we know what the actual numbers are. We don't want our clients to be surprised when they get their check and it's not as much as they expected. So I'm glad you asked the question. So the fee is typically a third, okay? There are some states that change that depending on the circumstances. For instance, New Jersey, I have a case that's settled in New Jersey, and the statute is a little bit complicated, but it's like the fee is a third of the first 750 grand. It's 30% of the next 750 grand recovered, and 25% of the next 750,000 recovered. In Massachusetts, there's a sliding fee structure for medical malpractice cases, but typically the maritime case is a third, okay? And that comes off of the gross recovery, okay? So in the $2 million scenario that you mentioned, well, let's say it was 2.4 million, so it's divisible by 3, okay? 800,000 is the fee on a $2.4 million recovery. It's a third of 2.4 million, okay? Now that leaves the client with $1.6 million, okay, in that scenario. From their portion, other distributions or deductions are made. The first is cost, okay? So I just settled a case which is in the neighborhood this week that that we're working on, okay? And my costs in that case were $85,000. What are costs? Okay, so costs are anything I had to pay for as the lawyer to advance the case. I pay the costs, my firm's account, out of my firm's expenses as the case is going on. And if I lose, this is a very important thing. If I lose the case, if I don't get a recovery, okay, then I'm not going to get my fee. I'm not going to get paid. So if you're injured and you're thinking about hiring me or any other personal injury lawyer, we'll take a third, but only of the ultimate recovery. If we don't prevail, you pay nothing. Same with cost. We advance the cost, we pay the cost as the case goes on, but if you don't get recovery, then you don't pay our costs. We eat them. So there are some states where that might be different, but not any that I have practiced in before. Okay, so let's take that 85,000, let's round it up to 100 just to make the easy numbers. So you get $2.4 million settlement, 800 comes off the top for my legal fee, another 100 would come off for costs. That gets you down to $1.5 million. Okay. Oh, and let me just talk about costs. When I file a case in court, the court is going to collect a fee for filing the case. Anytime I subpoena a witness, I have to pay for that subpoena. I'm going to take depositions in a case, which means I sit down with witnesses under oath, ask them questions. Very important to developing the evidence you need to prove a case. Every one of those witnesses I have to, if I'm not subpoenaing them, I'm getting them there by agreement of the other counsel, but I have to hire a court reporter to take down everything that they say and make a transcript. Those tend to be pretty expensive, depending on how long the deposition is, because we pay by the page. Expert witnesses can be crucial to your ability to prove a case, depending on the facts. So I'm going to have to pay an expert witness, and they can be very expensive, depending on the topic, the subject matter we're talking about. Doctors are very, very expensive. And even though they might be your treating physician, if they have to testify at trial or at a deposition, they're going to charge like $1,000 an hour. So it costs a lot of money. I have to talk to doctors once in a while to understand what they're saying about a client's condition and the permanency thereof, disability and that kind of stuff. Just to talk to me, they're going to charge me a couple grand just to have a conversation. copies can add up in a case. We're really never going to be paperless, but we try to not make as much copies as we used to, but those add up. Mail, so that adds up. Medical records. We have to have the medical records. We have to have them certified to get them into evidence. And it is incredibly expensive to pay hospitals and doctors for the fee that they charge for us to get the medical records. There are other costs, but those are the main ones. So those can add up. Okay, we talked earlier about liens. So if any medical bills have been paid by a private insurer or by Medicare or Medicaid, either at the federal or state level, you have to negotiate a settlement with them. Okay, different standards. So let's say a particular client, let's say the case we talked about, has $400,000 in medical bills. Okay, and $200,000 of them were covered by maintenance and cure, but now there's 200 that weren't. And of that 200, 100 was Medicare, Medicaid, and 100 was to a hospital that the bill never got paid. Well, we have to deal with all of that stuff. So the Medicare lien, we can negotiate with them, and they might take a reduced amount depending on a bunch of circumstances. And for the private entity, the hospital that hasn't perfected their lien, we might be able to negotiate even better with them. But those numbers have to come off the top. So come out of the net amount to the client. So back to our scenario, let's say there's 200 in unpaid medical bills, there's liens, and we can't negotiate it. There's another 200 that comes off of that what's now 1.5, and it gets to 1.3. If there are any other liens, sometimes we have clients with child support liens. Sometimes we have clients that owe the IRS money. Okay, they get their money before the client gets theirs. The other thing that we see a lot with clients, and this is the sad reality of the gaps in protection for fishers who are injured on the job, is since they don't get wages paid through workers' comp or some other form, and only get the maintenance and cure, we have a lot of clients who have a hard time making ends meet while their case is going on. And so they end up taking litigation loans, which are very high interest loans, just so that they can put food on the table for their families. And, at the end of the day, they have to pay those loans back. And with the interest rate that they're charged, those can be very, very expensive. So let's say this same client has $100,000 that they've taken in litigation loans. Now they're down to 1.4 million out of their total recovery. So that's just kind of an example, Megan, of how those distributions and deductions get made. And the numbers, I think everyone would sit there and say, okay, well, out of the 2.4, I'm getting 1.4. That's a pretty good payday. But if the settlement wasn't as much, you still might have those large deductions on the other side. They can add up and really change the final outcome for a client. So we try to keep everybody. We try to let them know up front. We do let them know up front, and we try to keep them informed over the course of the case about, hey, you got this big lien here. Just understand it's going to have to be dealt with. And, in a big case, like a $2.4 million case, we always talk to the clients about big costs. So if we're going to hire an expert, the client's going to sign off on that. We're going to let them know we have to hire an OSHA specialist or an industrial hygienist, and they're going to come in and testify about why this workplace was unsafe, but it's going to cost us $10,000. We think it's worth it because your case, again, the poker analogy, there's a lot of chips on the table here. You've been really hurt bad. We think it's worth it, okay? And the client will agree or not to agree to that. It's always the client's call. But in a smaller case, we say, look, we'd love to hire an expert, but we don't think the juice is worth the squeeze here because you're going to have to pay for it. And at the end of the day, there's just not going to be enough left. Sometimes that's a difficult decision to make, but one we do make with the client's awareness and knowledge.
Well, it's very clear how much you do care for your clients. And it's really nice to know that you're generally someone who's on their side. And wondering, because you do such a great job explaining all of this in detail to people who don't really understand the legal world. Because I mean, we have other things that we're professionals at, experts at. But so how do you communicate with your clients? Like, how do you keep them updated on their cases? I know cases can go on for years, like you said. So what is the initial, talking to Michael? We sit down with you, or do we talk over Zoom or a phone call? Like, what is the basic lines of communication for you?
So I have a relatively small firm. There's me, and right now there's 3 other lawyers of varying degrees of responsibility and experience. We also have a staff, so there's a few paralegals. And as I mentioned, we have a client service coordinator who is really the front line and the first point of contact for all of our clients. So Jim's phone is on 24/7. And he's, like I said, the first call will usually go to Jim if a client wants to know what's going on. But even before that, let me explain a couple of things. So when you hire my firm, you're getting me. So if your case is going to get tried, I'm going to try it. It's not like you're hiring some firm that has offices in every, city in the country. And, there's a name for that firm. But when you hire that firm, you're not getting the guy whose name is on the firm. You're getting some guy in the local office or some woman in the local office. They might be a great lawyer. I'm not saying that they wouldn't be, but let's be honest. You're not getting the name guy. My firm, you're getting me. Okay. And you're getting my staff. So there's an individualized attention to each case that comes with a smaller, leaner operation. And like I said, I'm the trial guy. So, but I will have all of the staff working on the case. I usually assign it to one lawyer and one paralegal, depending. There's some exceptions to that. And in addition to that, Jim is always there as the everyday point of contact for clients. Either come into New Bedford and see him if our clients are from there, or give him a call. I give my clients my cell phone as well if they want to reach me. We also have a texting service, Connect, so that our clients can send us a text at any time, and that automatically gets routed to us and responded. The other thing that we do is we have some internal policies and protocols set up. And one of them is a 30-day client contact policy. So what we do, and we have case management software that we have automatic reporting on and a tickler system. And so basically what happens is every 30 days, we require ourselves to reach out to our clients and find out, how you doing? What's going on? Is there any development on your end? We try to tell them what development there is on our end. And sometimes it's even like, hey, nothing's going on. Just wanted you to know. But, just want to touch base, see if there's anything you think you should let us know about your case. So that's something that we certainly endeavor to do. And it's our practice to do that every 30 days in every case. So that's important to us. In addition to us always being available if the client reaches out to us, the aspiration is to get in touch with them every 30 days. When cases are more active, there's going to be a lot more activity, okay? And a lot more client contact, to the point sometimes where clients are like, God, let me get on with my life. I'm sick and tired of answering questions about, what you need in the case. So that's that's how our firm is set up and what we endeavor to do to keep clients informed. The other thing is, if something, I say big happens in the case, and if there's a result, a motion's filed and the judge makes a ruling, obviously we send that along to the client and talk to the client about it. When we write our demand letters, we copy the client on that. So we try to keep them advised more than just talking to them. We send them the important stuff that happens in a case as it happens as well.
Amazing. And thank you for this entire interview. We have a few questions left, but I want to say, I mentioned before that Michael Flynn is one of our sponsors, and I'm so proud to have you on. And one of the reasons is because of your work with the Seaworthy Foundation. And it really does show how big your heart is for the commercial fishing community, that you are actually putting action in behind it, more than just within your law firm. I'm going to let you explain further, but please tell us about Seaworthy. And thank you so much for all the work that you do with that, and former commercial fisherman's wife as well.
You're welcome, and I really appreciate those kind words. And the opportunities to talk about seaworthy. So I mentioned earlier in the interview, I think your question I was answering was, tell me a case that really impacted you, and I was talking about the case which led to the formation of Seaworthy. And that was a case where two of my clients lost their family members. One client, Tammy, lost her husband, Mike, and another client, Phil, lost his son, John. And we litigated that case. It was a hard-fought litigation. We ended up with what I thought was a pretty decent settlement. And we dedicated ourselves, and I mean ourselves, me and Tammy and Phil, to doing something more with it, because a monetary settlement is just money. It didn't bring John back, and it didn't bring Mike back. And I think the three of us all felt an obligation to them and an obligation to what we had experienced over the course of that, of dealing with that tragedy and then the litigation that ensued, of not stopping with the settlement, of trying to make a difference. That's always been important to me, especially at this stage of my life. I'm pushing 60 now. And, I felt like, okay, I'm doing okay with the law firm. I'm making a decent living. My kids are all grown and out of the house. And Nancy and I, my wife, it was always important to us that we give something back. And we always try to find a way to give something back. And I felt like this was a deeper calling, a larger calling for me to, okay, this is your chance to do something meaningful in life. And so Phil and Tammy and I, when the case settled, we all pooled together some of our money and provided the initial funding for a nonprofit that we call Seaworthy Foundation. You can reach us at seaworthyfoundation.org or send me an email about it. And what we did was, so it's the Seaworthy Foundation for Commercial Fishing Vessel Safety, and it's named in honor of John Saraiva and Mike Roberts, the two crew members who died in the sinking of that vessel. And what we're trying to do is find different ways that we can put our resources to use to improve safety in the commercial fishing industry, and we're trying to do that in a bunch of different ways. We are a 501c3 nonprofit. So if you feel moved to donate, we're always looking for help financially. It's hard to run these kind of things, and it's hard to fundraise. It's probably our biggest challenge, but we're always looking for people to do that. You can do that on our website or our Facebook page. We have PayPal, so you can pay through PayPal. Sorry about that plug, but you got to do it.
Bring it on.
So anyway, I'm the executive director of the foundation. Phil and Tammy are on the board, along with a few other members, including a woman, Annette, who lost her son in the sinking of another vessel, which happened a couple of years later, under very similar circumstances. And Scott Fulmer, who is a researcher and a professor, adjunct professor at the University of Lowell, but he's an industrial hygienist and an ergonomist. Jim, who I mentioned earlier, and my partner Lori Workus are also members of the board. Right now, and you can, like I said, go to our website to find out a little bit more about us. Right now, what we're trying to do is communicate about fishing safety. So you asked me a question earlier about education. And so this doesn't go directly to fishers, but whenever I have the opportunity to speak on behalf of Seaworthy, I do it. So I've given a few presentations in the community, including a local radio interview and some other press conferences that I've given. But I also spoke at the iFish 6 conference in Rome 2 Januaries ago. And I've recently joined the global iFish platform as a United States, I don't want to say representative, but as a United States member. So that's kind of what I'm doing, advocacy in a larger area, and that's for Seaworthy. That's not for my firm. The other thing that we're doing, and these things take time, but the first thing we're doing is, and we're really proud of this, Seaworthy sponsored Scott and I in, long story short, we were asked by the National Institute of Health, which is part of the CDC, and they are kind of the research arm of NIOSH, which has a lot to do with oceans. But they have a federally funded collaborative agreement program with the Coast Guard, and they asked us to submit a request for a research project, which we did, and our funding request was approved. So it's not an insignificant amount of money, and we've been approved to study the role that stability or lack of stability plays in causing fishing vessel casualties, sinkings, and injuries, and to try to figure out why it is that the Coast Guard has not adopted mandatory stability regulations for commercial uninspected fishing vessels as they've done for larger vessels. For those who may not know what stability means or what that concept is, it's essentially when a vessel is in the water, the vessel is going to rock back and forth. We all can kind of have a vision of that, right? On the waves, on the weather, whatever. And stability, in a simple sense, is the vessel's ability to right itself. In other words, to come back to square, come back to center when it's keeled over one side or the other, right? And the ability of the vessel to do that is dependent on a bunch of factors. There's a lot of physics involved in this, okay? But basically, what's called a righting arm. The righting arm is when you calculate all the variables, the righting arm is what dictates the abilities of the vessel to come back to center. And if the righting arm is impacted negatively, that means that the vessel can keel over just a little bit and then it's going to capsize. Whereas a vessel with a stronger righting arm can go way over, but it's so stable that it's going to come back to center. So obviously, if the righting arm is not good, the stability is not good, the vessel is more prone to capsize. And there's a lot of variables that affect that. And we see, especially in the Northeast, we see vessels that are prone to have their righting arms negatively affected and to make them more prone or less stable and more prone to capsize. Just as kind of in a general sense, we see a lot of vessels that were built in Louisiana for shrimping in the Gulf of Mexico. You heard me, the Gulf of Mexico, okay? And that fishing is entirely different. And it's, I'll just say it's a lot lighter and less cumbersome or less strenuous on the vessel itself. Well, a lot of these vessels have been retrofitted. They get bought by an owner or owners up in the North Atlantic, and they get turned into scallop vessels. So they carve out fish holds. Shrimp gets dumped on the deck, and they come back, to Galveston or wherever and sell it, in a day. Scallop fishing, they're out there for a couple of weeks, and they got to put the scallops on ice, so they have to create a hold. The equipment, shrimping's nets. Scallopers are these heavy dredges with a bunch of heavy equipment. Bottom line is, to make a shrimper into a scallop vessel, there's a lot of weight above the center of gravity that's added, and that's the number one negative impactor on the righting arm and the vessel's lack of stability. So 95% of the United States' commercial fishing fleet is comprised of what we call commercial uninspected fishing vessels. Those 95%, those vessels are responsible for 80% of vessel casualties, yet they're largely unregulated. So those vessels are 79 feet or less in length, and they tend to be older by definition. And the regulations which apply to them are very, short. They have to have life-saving equipment, EPIRBs, a life vest, a lifeboat that automatically, inflates. A couple other things, some training requirements, the survival suits, but that's about it. Whereas the bigger, newer vessels have very, very robust, detailed regulations, including regulations pertaining to stability and stability testing, but not on commercial uninspected vessels. What's interesting about that is that in 2010, Congress told the Coast Guard, and the Coast Guard is the primary regulating agency for fishing vessels, you gotta adopt minimum stability regulations for those vessels, the commercial uninspected vessels that make up the fleet and cause most of the casualties. And here we are 15 years later, and the Coast Guard still hasn't done it. Recently, in 2022, the General Accounting Office of the United States government issued a report which looked at the Coast Guard's performance since the congressional mandate in 2010 and listed all of the things that the Coast Guard has done and those things that they failed to do, and took particular note of the failure to adopt minimum stability requirements and regulations for commercial uninspected fishing vessels. And the Coast Guard's response was that they believed that they did not have the legal authority to do so, despite Congress very clearly telling them in 2010, you got to do this. And that's where things are right now, at least in the paper war between the GAO, Congress, and the Coast Guard. I shouldn't call it a war, but at least on paper. So we're trying to get to the bottom of that. The first thing we're trying to do in the first stage of our project, and we're underway, by the way, we just sent our FOIA request to the Coast Guard. We're actually working with the Coast Guard, who sponsored the project, or the Coast Guard is supportive of the project. So actually, when I spoke in Rome, I spoke with a Coast Guard representative on this presentation. We're cooperating and collaborating. We're getting guidance from them on the FOIA request in particular, and hopefully on the FOIA response. What we're going to do in the first stage is we're going to look at all of the casualty investigative reports that had anything, and to try to figure out how many of those accidents, and this goes back to like 1988, how many of the casualties stability played some role in. And then from there, in the second stage of the project, we're going to try to find out the correlation or lack thereof between those results or those statistics and moving that congressional mandate into action. And if things play out and, the best case scenario for us, the dream scenario would be us testifying about our findings, getting them published in a peer-reviewed source, and then going to Congress and testifying, hopefully before a congressional hearing, to finally get these regulations put in place. That's what we're looking for, ultimately, and see what happens. So we're very excited about that. We're underway. We're in the first phase, and things will move along a little quicker when we get to the FOIA response. So very exciting for us.
It's exciting for us too. Thank you so much for the work you're doing. That is all we want, is for our fishermen to come home safe and to have safe fishing vessels that they purchase, that they fish on, and that we can all thrive for generations to come. So thank you so much. That would do so much to help the mental health of partners of commercial fishermen. I can tell you right now, anything that is addressing a fisherman's safety is going to bring ease to the partners and their families. So thank you for that.
If I can just interject. So a couple of things about that. So vessel owners that are listening to this, of course, going to say, well, if I've got to, do mandatory stability testing, how much is that going to cost me? Because if you go to a naval architect and have the testing done, that could be pretty expensive, and that may or may not be true. Okay. But I understand that a vessel owner is going to have that pushback. That's all I can say. I can't dictate to a vessel owner that what the expense will be, or try to convince the vessel owner that it's worth it or not. But there really hasn't been any safety measure in any industry in this country that hasn't really come without the imprimatur and the force of congressional mandate. And most of the time, industry does come kicking and screaming. And in most of the time, they recognize after they do it that there's actually profit in safety. And that's another topic for another day. But that's all I'll kind of throw out there for the vessel owner who's concerned about the cost, is you actually might realize that there is profit in safety. Again, we could talk a lot about that. The other thing I want to just say about Seaworthy is we have a couple other initiatives that are kind of in the beginning stages. We're trying to follow the lead on a couple of nonprofits that kind of have a similar mission to ours. In particular, the Fishing Partnership in New Bedford, the work that they're doing there. They have a pilot program. I don't know. I think it's actually a program that they follow all the time now. So I think it's more than a pilot program. But what they did is they worked with a manufacturer to come up with a flotation device design that would not encumber a fisher's ability to do their job, so that they can wear it all the time. And they've had a lot of success of actually putting those in the hands of or on fishermen. And so we looked at that model and said, and this is where my practice intersects with Seaworthy, is I got a lot of clients with head injury. And, I feel like a goofball when I ride I'm in Florida right now. I ride my bike all the time. My wife and I ride our bikes all the time. And I hate wearing a helmet because I think I look goofy in it, right? And it messes my hair up, what little I have left. But all kidding aside, I wear it. And I wear it because I know if I fall off that bike, maybe I'll break my arm, but at least I'm not going to break my head if I'm wearing that helmet. So we've got a program that we're looking at right now, and we're going to try to do the same thing with helmets that the fishing partnership, for instance, has done with flotation devices. Try to come up with a cool, unobtrusive helmet design that fishers will feel like it's not too uncomfortable or too much of a hassle to wear, so that at least head injuries could be diminished. And the other thing we're working on, because we also, again, intersection of the legal practice and Seaworthy, I see a lot of cases where fishers are on a boat maybe for the first time, or they encounter a situation on a boat for a first time, and it results in an injury. And had they known of, for instance, a blind spot on the boat or a particularly dangerous spot on the boat, they might have been able to avoid it. And so we're working on a project called vessel mapping. We're actually right now applying for a permit in New Bedford to have a physical presence on the docks, like a booth almost, so that we can meet fishermen going to work and coming from work and ask them while it's still fresh in their memory, like, hey, you're on the, Santa Maria. I'm making that name up. If it's a real name, I didn't mean to point to that vessel in particular, but you're on this boat. You just spent a week at sea. Let's map it out. Where are the dangerous spots? Where are the parts that you think like, an injury could happen there? And we hope to eventually map all of the vessels in the fleet, at least in New Bedford and Fairhaven, so that we can now give those to guys that we know are fishers. And kind of gets back to your question about what are you doing for education in advance of injuries. And this is certainly one thing that we're looking to do in that regard. And hopefully, if we can give a guy a book, he can look at it or she can look at it and say, oh, okay, I'm going on this boat next week. I've got the map. Now I can kind of feel like I'm a little bit safe, and maybe ittle prevent an injury or two.
Love it. Please keep us posted as those come about. We would love to learn more about
Absolutely.
how we can get involved and how it has, come into fruition. So I will put all the notes for Seaworthy also in the show notes, as well as Michael's contact information. And now for the quick fire questions from our community. So this is going to be a challenge because we have a good handful of questions, and let's see if we can do it in like a 10-minute hot seat. All right.
Sure.
Okay. Yeah. Number one, I got all these questions, by the way, from our Instagram, our private communities. So thank you so much for answering them in advance. Number one, why are fishermen 1099 employees?
So the vessel owner doesn't have to bear the expense of having an employee. Simple. That's it.
Okay. That's it. All right.
And because I guess they can.
Okay. All right. Next. This is for California, why don't California game wardens adhere to the same search and probable cause laws as the regular law enforcement have to follow? For example, a couple of wardens came down to the dock, jumped on a guy's boat, and just tore through it, searching every nook and cranny, and no search warrant and no probable cause.
So my initial question is going to be, I have no idea. Okay. That's what I'm going to say. Quick disclaimer. I don't practice that area of law. I'm a personal injury trial lawyer who specializes in representing injured fishers. Okay. That said, okay, what that question should be directed to is really a criminal lawyer who has expertise in search and seizure. Okay. Again, not what I practice, but I think we all have an understanding that the Constitution, I think it's the Fourth Amendment, protects against unreasonable searches and seizures. And that brings into play probable cause, and under what circumstances has enough probable cause been triggered such that there is a right to an investigation. That said, depending on what agency conducts the investigation, they may have statutory authority to do certain things. They can't violate the Constitution. And so I would hire a criminal lawyer or spend some time or money talking to a criminal lawyer and figuring out whether or not the search that was perpetrated was authorized, was unconstitutional, and then to figure out what the remedy would be after that. Okay.
Great.
And I could say this: if fruit of the poisonous tree doctrine, if there was an unreasonable search and seizure, any evidence obtained by that is going to be inadmissible in whatever prosecution they're trying to bring after that. Okay.
Okay. Thank you for that. Okay. Next question. And as you mentioned, your type of representation, however, what guidance would you have for somebody who has a question that says, can we sue Fish and Game for keeping our permit money and not letting us fish?
I don't really even know what's being asked by that question. I don't mean any offense, but that question seems to be broad, that it could touch on a lot of different things. Okay. So I really don't even know how to answer it. I can say this, that again, I don't specialize in that. And you mentioned it, Megan, but there are lawyers who do. So if you wanted to contact me offline, and I could, depending on where you're at, I could probably put you in touch with somebody who could answer that question for you.
Okay, great. This person I know is in California, and I believe in reference to the salmon fishery closures. So, okay, I'll give her your information for sure. Another question: can we sell lobster tails with the proper licensing? I realize, this is a state by state thing that you mentioned, but maybe you have advice on where someone can get answers about this.
I do. Again, call me online. I pretty much know exactly who to go to on the lobster question.
Amazing. Okay, here's another one. This is from a private community member. A big thing in clamming is pulling up old bombs, especially mustard gas near Long Island, New Jersey. I had no idea about this, by the way, until I heard about this.
Pretty crazy.
Yeah, it's not just mustard gas, it's bullets and other things that have been dumped. They become pressurized at the bottom of the ocean, and when they come up in the dredge, they become unstable and explode even as fishermen try to throw them overboard, as if partners of commercial fishermen have enough to worry about. So who is responsible? The government? And if so, how does a fisherman get compensated for something like this if an injury occurs?
So that depends on a lot of circumstances. But if the dredge pulls up something that's hazardous to the crew, okay, then the captain is going to have to respond to that in a reasonably safe way. Okay. And if they don't, then, and it causes an injury, then it's going to be compensable under the Jones Act. Now, what the vessel owners, what the lawyers hired, so let's say there's an injury, one of these things is pulled onto the boat and it explodes, and there's arguable negligence on behalf of the captain. And this is a long time ago during this conversation, I talked about the in whole or in part causation standard of the Jones Act. Okay, so you look at that situation, you can say, well, the main cause there is the fact that the government allowed this stuff to be at the bottom of the ocean where they're also allowing fishing. What the heck? Okay, yeah, fine. But one of those causes was the fact that the captain knew it was in the dredge and dumped it on board anyway, and it blew up. Well, that's enough to make out a Jones Act case, especially if that they had encountered it before, right? It wasn't just the first time, some freak accident. Okay, so there's going to be a claim. Now, the lawyer in this situation for the injured fisher is probably not going to pursue anything more than the fishing vessel under the Jones Act, because that's the easiest path of recovery, and it's all provided for. But the vessel owner's insurer, they're going to hire a lawyer in this theoretical claim, and they can bring into the lawsuit the government, and there'll be immunity and things like that might come into play. But if there's a third party attributed to cause the injury suffered on the boat that the fisher is suing the vessel owner for, the vessel owner has a right to seek contribution from any third party that they feel is the real culprit. Okay, and there's provisions in every state law under what are called joint tortfeasor acts to allow that to happen. And the law under the Jones Act recognizes that the vessel owner has the right to do that. not to the detriment of the injured fisher, but certainly to protect its own interests and seek contribution. So what that would mean would be basically the vessel owner might have to pay the fisher, but then the vessel owner can get contribution for the amount it has to pay to the injured fisher from whoever the responsible third party was. I have a case right now where my client was on a clam boat off the coast of, I'll just say in the Northeast, got injured. And then during medevac, they had to bring a helicopter in because my client's injuries were life-threatening. And and it wasn't the Coast Guard. For whatever reason, the New York City Police responded. And they, in the course of airlifting my client, the vessel owner is claiming that they dropped him and caused additional injuries. And so they may be seeking contribution from the New York police, but they still owe my guy. And we haven't sued New York, but they have third-party rights against it.
Wow. Okay. Thank you for clarifying. And the most important question of all, how can people get in touch with you? What's the best way to reach you?
Okay. So my office number is 617, phone number, 617 area code, 773-5500. Easy to remember, 773-5500. My email address is mflynn, Mike Flynn, at FlynnWorkus, WIRKUS, as in Sam.com. That's my partner Lori's last name, Flynn Workus. We can also be reached through that number on the Connect system, the main number. And what's our website? FlynnWorkus.com. We can also be reached through that.
Awesome. Michael, thank you so much for your time. Thank you so much for your incredible sponsorships. And thank you so much for your dedication to our fishing community through the Seaworthy Foundation. And we are just so thrilled to be able to spend time with you and to have your knowledge broadcasted across our entire community. So thank you for being here. We so appreciate you.
Right back at you, Megan. You're welcome. But thank you for all that you do. I mean, what you're bringing to the community is so unique. It's so passionate and it's so helpful. So please keep doing what you're doing.
Thank you, Michael. We'll talk again soon.
All right. Sounds great.
Bye.
Thank you so much for listening. To support our community, I'd so appreciate it if you tap the subscribe button to this podcast or write a review. And if you're a POCF who wants to connect further, go to POCFpride.com for weekly vlogs and to learn about opportunities to join our private communities. We'd love to have you.